Hello, my true crime lovelies. How are you? All right. Remember that video I did where Lori was filing for a new trial? I had the thumbnail, it said Idaho or bust, and then I crossed out bust and put in new trial. For someone who's dying to get back to Idaho, why would she file for a new trial? Well, the judge has answered her. So I've got the judge's response. But before we get to the judge's response, I want to go through the trail because she didn't just file that. Then she did that. The state filed a response. Then she filed a response to the response, like trying to give Miss Trina K the business. And let me tell you, it's not enough hours in the day for Lori to get up early enough to outsmart or outright Miss Trina K. WRITE. So I'm just going to go through the trail because there was a 6-page letter that she wrote that I wanted to read before, but I was taking a mental health break. But we're going to walk the steps, and then we're going to talk about Judge Boreski's ruling, who he's not too shabby with a pen himself. And that old noodle, he didn't get to be Zaddy Boreski on accident. First, I'm going to run the intro. Thank the members. Thank you for being here. I hope you are as lovely in life as you are in my mind. I'll see you on the other side. Okay, I'm going to link the prior video that I mentioned earlier in the iCard so you can take a look at it. But just as a quick refresh, Lori went into all of her medical business in that motion, and she was complaining that she was sick and she had a virus, but she had to take antibiotics, which a bunch of people are like, you don't take antibiotics for a virus, which is true. But you'll see in this video, she had a UTI. And so then that's why she needed the antibiotic. So it sounds like she's alleging she had a virus and a UTI. But first, before we get into that, because she mentioned all of her medical records, the state, prior to filing their response, wanted to see her medical records.
Like, girl, what, you can't just talk about it. You got to be about it. You know what I'm saying?
So the state filed a motion to see her medical records, and obviously she opposed that because
she wasn't telling the truth. But oh no, wait, HIPAA.
The judge said the courts received and reviewed the state's motion for defendant's correctional health records as well as the defendant's objection. And then he clarifies the defendant put her medical condition at issue by claiming she was too sick to proceed with trial, contrary to the court's findings that there was no objective medical evidence to support the defendant's claim that she was medically unable to proceed to trial. The defendant also interjected a specific diagnosis into some of her pleadings for which there was no evidence other than the defendant's statements.
So, lying like a rug.
By peppering various pleadings with her alleged illness and medical diagnosis, as well as other references to her illness. I'm too sick to go on. She also disclosed otherwise protected information to third parties and the public, thereby partially waiving patient medical professional privileges. Over the defendant's objection, it is ordered granting the state's motion and directing Correctional Health Services to disclose to the state copies of the defendant's medical records for all services, assessments, testing, and treatment provided to the defendant, but he limits it to the time period of May 30th through no later than June 13th, and they'll provide it within 5 days. So then following that, the state got her medical records and they filed a response. But because it involved her medical records, they sealed it. Because, you know, if they didn't seal it, you and I would have been talking about it because I'm nosy. I wanted to know what it said. But so after that, the state filed a request to keep their motion for a new trial, their response, under seal, and the judge granted it. It is ordered granting the state's request. It is further ordered the clerk of court shall seal the state's response to motion for a new trial filed by the clerk on July 9th, not to be opened without further order of the court. Okay, so it was blocked. And then you would think, since Lori was already in an uproar about her medical business being out there, despite her telling us, she comes back with a 6-page response to that. The defendant, Lori Daybell, hereby requests this court to grant the defendant's motion for a new trial. There is violation to something for violation of medical evaluation, lack of impartiality, and abuse of discretion, denial of Rule 13, denial of Rule something 3.5 hearing, not releasing the jury, allowing gunshot residue and DNA evidence without sufficient foundation, and denial of right to confront witnesses. So she's like rehashing these things. And then she's calling it junk science, the DNA, the right to confront witnesses, Brady Rule, Fry Rule, Bill of Rights, U.S. Constitution Amendment 5614, like everything, Newton's third law, Strickland.
I don't know. Isn't Newton's law about gravity?
In the state's response, pages 3 to 6, 9 to 10, Miss Trina K acknowledges that the state is in possession of the defendant's medical, to which her colleague, Mr. Joseph Vigil, illegally obtained through MCSO, Estrella Administration, and CHS. Mr. Vigil filed a response to the court. Mr. Vigil did not obtain the results for the defendant's urinary tract infection. Ma'am. Because the test was sent to labs outside CHS and MCSO, therefore the record was incomplete. Well, it's complete now, girl, but I don't understand, like, who hasn't had a urinary tract infection? How does that stop you from functioning? And I mean, they gave you antibiotics, so how many days would it take to clear up? Usually antibiotics start working in like 3 days, even though you still may have 4 days left. So yeah, okay. They have diapers in the jail, I hear, because I've been watching all these death row videos, and I didn't know this, but it makes sense. They put a diaper on them before they execute them because they're likely to, or they don't put it on them, they give them one to put on because they're likely to clear their bowels. So she could have borrowed one of those if it felt like she had to go to the bathroom.
You know, just a suggestion, Lori.
Wait, the record was incomplete and incorrect, misdiagnosing the defendant's actual illness. CHS informed the defendant antibiotics were given for treatment. So on June 8th, they told her. I don't know how she's getting that wasn't in the record, even if it went to an outside lab. Because, like, I don't know about you guys, but when I go to the doctor, they will send my blood work out to a lab, but the doctor gets a copy and I get a copy. And then we talk about it. I mean, it's Quest, so I can see it online ahead of time, but you know what I mean. She's just flailing out the accusations. Everyone's wrong. They're lying. It's incomplete. They obtained it illegally. Oh, woe is Lori. On page 10, Ms. K states she had a viral infection and urinary tract infection. So this is page 10 of the report that's under seal. So Lori is putting it all out here for us to see. The judge ordered antibiotics. Therefore, Mr. Vigil misdiagnosed and incomplete record jeopardized the safety, well-being, deprived and violated multiple state something and constitutional rights of the defendant. How so? Can you specify, ma'am, which state or statutory, multiple statutory, which statutory which statutes were violated, which constitutional rights were violated? Please be specific. Mr. Vigil is not CHS civil attorney. Miss Kimberly Chamberlain is, because Mr. Vigil and Miss K admit to obtaining the defendant's medical records. which MCSO admin gained through CHS bypassing Miss Chamberlain. I don't know why it would need to go through the civil attorney. The judge already ordered it. What can she do? Who legally represents CHS and is obligated to obtain a comment, waiver, or court order. There was a court order to privilege patient physician records, holds Mr. Vigil, Miss K, the courts, MCSO, and CHS in multiple violations. Violations of what, girl? That was a court order. And as the judge said, you put it out there, and now you're adding even more. We don't know why. The discovery conflicts with the Bill of Rights in a direct manner. Then due process is the super something right, superior right. U.S. Constitution Amendment 6, the information sought includes information to which she is entitled as a matter of due process. The state and Mr. Vigil failed to produce the court for an in-camera review. Mr. Vigil on June 4th, 2025, read the defendant's medical records to the court, to which the public had access to obtain the results. No, we didn't actually. The cameras were off. I mean, I guess in the transcripts, but I would assume they would redact that.
Unless, of course, you object.
The courts did not seal until later. Physician-patient privilege cannot be compelled. I don't think it was compelled. I think it was ordered. A patient can only waive in writing or by consent or by court order. There was a court order under Arizona 332 something. The disclosure of medical records violates the defendant's right to confrontation clause, and then Sixth Amendment and HIPAA. The court abused its discretion by allowing disclosure of the medical records. Okay, so she's acknowledging there's an order now, but she's saying it was an abuse of discretion, not of power, and forcing the defendant to an evaluation. Article 6 of the Constitution, Amendment 4, Bill of Rights, yada, yada, word salad, statute splatter. The state fails to produce justification of lack of impartiality. The defendant has FTR to support the fact finding. FTR, so that's the the camera that's in the court all the time. Like when we saw her escalate her motion to get rid of Judge Boreski, we only saw it on the FTR because the feed cameras couldn't get in fast enough. Please hold. So perhaps her advisory council went back and looked at that FTR because she's got it down to the seconds. 3:50, 31, 3 hours, 50 minutes, 31 seconds. Anyway, the court supported the state's objections. Oh, wow. That's so impartial of him. The defendant was unable to admit exhibits as the state and the court continued to state she would open the door. Abuse of discretion, denial of Rule 13.5 hearing. The court denied requests stating the defendant was not entitled to a probable cause hearing. The state asked the court to proceed with 2 aggravating factors. The legal sufficiency of an alleged aggravating circumstance allows a defendant to request a probable cause determination for alleged aggravated or aggravators. The right, double jeopardy from subsequent prosecution on original charge. So no one was prosecuting you again. They were just going to mention to the jury that you're a murderer because you were knocking on that damn door. Okay. The court abused its discretion for late disclosure. Tammy LaChick's testimony, because Miss LaChick refused to testify during trial. But you didn't subpoena her. She just sent a note saying she was. She sent a note to the state who had subpoenaed her that she wasn't coming. The state presentation of expert testimony should have been excluded. when expert testimony is offered as evidence. What? The district court acts as a gatekeeper, excluding junk science that does not meet standards of reliability. Ma'am, are you calling somebody's stuff junk science? You who talks to your husband through a portal, you who can't die. Okay. An expert's testimony may properly be excluded if there is too great of an analytical gap between data and opinion. So what was the gap specifically? Which expert? Through expert testimony, cause will not be established, but mere guess and conjecture. Okay, and she cites some cases, General Electric versus Joyner. Nothing in Dobert-Frye rule or federal or state rules of evidence requires to admit opinion evidence that is connected to something data, lasting data, by something of the expert. And then she cites some more by allowing the GSR, gunshot residue, and DNA evidence without sufficient foundation and the denial of right to confront witness. I don't know which witness, unless she's talking about LeChick, but there were other witnesses who were actually testing the DNA. I believe LeChick was just the collection, and other people witnessed her collect it. It was like Alex's blood and some other stuff. Alex's DNA in the Jeep. I don't know what her point is. Like, that Alex wasn't in the Jeep? Who was it then? Who drove your Jeep from Idaho to Arizona if it wasn't Alex? Because he was in the car that track phone was, at least, as the expert would say. There's evidence that the phone traveled that way. And we know his Gmail was on that phone. So what is your point? I feel like she's trying to find a technicality, but even if that was removed, like, what does that prove for her? Like, how does it prejudice her if it's not removed? What happened? On page 8 of the state's response to motion for a new trial, Detective Pillar, case agent, he observed LeChick collect the GSR and DNA, right, swab testing, then stated he was trained on how to collect this type of evidence. Detective Pillar is not a forensic technician, nor is this his expertise, establishing a mere guess and conjecture. But he doesn't have to be a technician in order to have been trained on that. I have been trained on wine tasting, but a sommelier, I am not. That was before I gave up the alcohol. Testimony on behalf of Ms. LeChick should have been excluded due to analytical gap between data and opinion, junk science. Ma'am, do we want to get into data and opinion? Is that a thread you want to pick, Ms. Daybell? The court abused its discretion by failing to inform the jury on the record and in front of the parties that they would release. Okay, this one is just silly. That has no bearing on your case. They had already decided you were guilty. Conclusion: based on the above fact finding, the state has failed to actual facts to support their claim. The state lacks justification in all of the above. The defendant's request for a motion for a new trial should be granted based on bias, prejudice, abuse of discretion, and most importantly, the violation of admonition, which the state is desperately avoiding.
What admonition was violated? Do tell.
Then she just lists who is that's going to be sent to. And then let's go into what Miss Trina K had to say. Because, baby, It's always fresh and sassy. Okay, reply to defendant's response to state's motion to file state's response to motion for new trial under seal. The state of Arizona, through undersigned counsel, submits for the record that the state is not in possession of any of the defendant's medical records. I think they just reviewed them. I don't think they took control and custody of them. All information relating to the defendant's medical diagnosis comes from the defendant stating the facts on the record or from Joseph Vigil on behalf of Correctional Health Services, CHS, in a filing or on the record. If the defendant objects to sealing the state's response to defendant's motion for new trial, then the court should deny the state's attempt to protect the defendant's personal medical record and make the state's response to defendant's motion for new trial available to the public to view. Submitted July 13th. Baby, the judge never made it public because you and I would have talked about it. We would have loved to have seen that. But Lori is so silly. She will cut off her nose to spite her face. Okay, so let's get to what Zaddy Bareski had to say. Minute entry. The court has received and reviewed the following: defendant's motion for new trial with attached exhibits filed June 23rd. State's response to motion for new trial filed June 30th. That's the one that's under seal. Defendant's reply to state's response to defendant's motion for new trial filed July 10th. The defendant's motion argues three separate areas she believes warrant a new trial. First, the defendant argues she suffered a due process violation by being made to proceed to trial when she was too sick to do so, and the court further violated her rights by seeking an objective determination of the extent of her illness. Methinks the lady doth protest too much, so we need some evidence. The defendant's motion for new trial raises new allegations regarding the extent of her illness that was not part of the record during the course of the trial. This issue was resolved during trial, and the court has not been presented with any new, reliable evidence indicating the defendant's illness negatively impacted her ability to proceed with trial. The record and observations of the defendant's physical appearance, questioning of witnesses, and arguments to the court and jury all evidence the opposite, that she was able to proceed to trial. And she was sassy. She wasn't even like a little bit like feigning illness. Remember when he had to ask you to leave, ma'am? When he had to ask you to get out of the courtroom and talk to your advisory counsel? Girl, sit down, shut up. I'm so sick of you. Of course, he said it in a judicial way.
Then all 404B is in, or do we get a hearing on what 404B can come in? If I open the door, do I get a hearing? We stop trial and I get a hearing on...
Stop. We'll have a very short hearing, okay? If you're going to introduce how you have great character and good character, we're going to have a short hearing on what evidence that they can bring in to rebut that character, which could include being convicted of 4 murders. So
and would you
talk
like...
to your advisory counsel during the break. And
you don't need to yell at me either.
Okay.
Yeah, you are. And you do not need to talk to me that way. I'm very courteous. I'm very courteous to you.
No, you have been nothing near courteous to me during the course of these proceedings. Talk with your advisory counsel about the rest of your cross. We're going to resume in 15 minutes.
Pipe down.
The second point raised by the defendant is an allegation that the court lacked impartiality because of the court's evidentiary rulings. The defendant first argues that evidence of impartiality exists because the court sustained 2 hearsay objections from the state when the defendant attempted to cross-examine police officers about statements made by neighbors. The defendant's own motion establishes these are the very definition of hearsay statements. When ruling on evidentiary issues, there is no rule or case law that requires the court to allow a response from the opposing side.
So he don't have to hear from you, ma'am.
The defendant argues, and that was one of the things in the first motion, because she was like, she asked for a sidebar and he denied it. Well, he's saying he can. There's no rule that he has to hear what you have to say. after an objection as the opposing side. The defendant argues in her motion that one of the statements was not offered for the truth of the matter asserted, different description of vehicle, but for the effect on listener. The defendant never articulates what effect on the listener the statement would have. The defendant also never articulates how, if that statement came into evidence and it was not actually offered for the truth of the matter asserted, which appears to be the only reason the defendant wanted the statement entered into evidence, it would have changed the outcome of the trial. Yeah, because different people thought it was different colors. But if, like, you should have called those witnesses, ma'am. You can't ask the officer, what did they say? The defendant then argues, don't pull it. The defendant then argues she was unable to admit several exhibits. So I think she's talking about the pink pony video here. The defendant then argues she was unable to admit several exhibits and she could not effectively cross-examine witnesses regarding Melanie Boudreaux. These are, again, basic evidentiary issues which were ruled on during the trial. Just because the defendant does not agree with the court's rulings does not mean she is entitled to a new trial. The defendant never articulates how or why the court's rulings were wrong or how the rulings constitute a due process violation. The third area of argument is titled Abuse of Discretion. She argues, one, she was entitled to a Rule 13.5 hearing on aggravators. That's the probable cause thing she was talking about. The court did not release the jury from the admonition on the record. 3, the court erred when allowing scientific evidence regarding gunshot residue and DNA to be presented to the jury. And 4, she was denied a right to confront witness LaChick, although it's spelled not that way here. The first 2 points in no way have anything to do with how the jury viewed the evidence or deliberated. Therefore, would not be the basis for a new trial. Right, because the aggravators were after she was convicted. The court ruled on 13.5 request, which is essentially moot given the fact that the defendant chose to stipulate to the aggravators rather than have that evidence to be determined by the jury. The defendant is correct that the jury was not released from the admonition on the record, but there is no rule or case law requiring the jury to be released from the admonition on the record. The court did go back to the jury room and release the jurors immediately following the defendant's admission to the aggravating factors. Again, the defendant never articulates a reason why this would entitle her to a new trial. Right, because they were done at that point. The defendant's argument about DNA and GSR evidence seems to be more of a chain of custody or foundation argument than the substantive argument about the reliability, no substance to her argument, about the reliability of the evidence. The defendant's reply for the first time mentions the evidence being junk science, but she never presents any actual evidence or authority to establish the evidence was not reliable. Moreover, if there were questions as to its reliability, a competent and thorough cross-examination could have revealed those issues for the jury to consider. Oh, wait, was her cross-examination not competent, not thorough, Judge? Dare you say? Although the state chose not to call the person who actually collected the evidence, LaChick, also spelled C-I-K here, the state satisfied the foundation requirements to admit the evidence through Detective Pillar, who, meaning they laid a foundation, who was present during the collection of the evidence. The reply also alleges hearsay statements from LaChick Okay, I think they did an autocorrect, or not an autocorrect. They did a spell check, and then it came up obviously like with probably a red squiggly, and then they put add to dictionary, not noticing that the I and the C were inverted because it's consistently misspelled that way. Just for my fellow editors out there. The state satisfied the foundation requirements. Okay, the reply also alleges hearsay statements from LeChick were allowed into evidence, but does not state what those hearsay statements were. It is the court's recollection that no statements of LeChick were offered or admitted. They weren't, Judge. You're remembering correctly. What was she going to say? Ooh, that's some goopy blood I'm scooping up here. Finally, the court in no way precluded the defense from investigating this witness, as the defendant alleges. And in fact, the defendant could have subpoenaed and called this witness if she wanted to question this witness. Facts. The defendant fails to establish any due process violation which would warrant a new trial in this matter. It is ordered denying the motion for new trial. Have several seats, ma'am. That's what the judge is saying. Have several seats. So there we go. All in one video. The saga of the new trial and the denial, as we all knew was coming. So, girl, get ready, because Friday you're getting sentenced. Ah, you're going to have to listen to your victims. You're going to have to sit there. I mean, you could pretend to be sick, but we know how that ends. So, suck it up, Buttercup. We'll see you on Friday. What do you guys think? It's almost over. Will she go quietly into the night? Or will there be more? Let's talk about it in the comments. I'll talk to you later. Toodles.